Welcome everyone to labor rights under the USMCA. As you probably noticed from my last comment, this webinar is being recorded. We would ask you to please mute your microphone and consider turning off the video feed on your camera while the speakers are speaking, and we can turn everything back on when we come back after the speakers have spoken and we come back to a Q&A period. Again, welcome and thank you for being here. We want to offer special thanks to our co-sponsors today. First, the International Interest Section of LERA. The International Interest Section exists to promote dialogue, research, and evaluation of international institutions and processes in employment relations, and to encourage the comparative analysis of employment relations systems and types. Also, the U.S. branch of the International Society for Labor and Social Security Law. This organization is devoted to the international and comparative study of labor law and to close collaboration among academics, lawyers, and other experts. It's perfect for anyone interested in international and comparative labor law. And if you're interested in joining, feel free to email either me or Janice after the program today. I'd like to introduce our speakers. My name is Rick Bales. I will be moderating. I am a faculty member at Ohio Northern University. I am currently teaching at the Peking School of Transnational Law in Shenzhen, China. Although I'm teaching remotely from Mars, Pennsylvania, thanks to travel restrictions. And I'm president of the US branch of ISLSSL. Our first speaker today will be Janice Balache. She is the Samuel A. Blank Professor Emeritus of Legal Studies and Business Ethics at the Wharton School at the University of Pennsylvania. She is president of the Global ISLSSL. Her research focus is on how international human rights concepts shape regulation and corporate behavior. Our second speaker will be Jim Brudney. Jim, you want? Perfect. Jim is the Joseph Crowley Chair in Labor and Employment Law at Fordham University School of Law. Among other things, he is the co-chair of the Public Review Board for the UAW and a member of the Committee of Experts for the ILO. Third speaker is Lance Compa. Lance?
Hello, everyone.
Lance is the senior lecturer at Cornell's School of Industrial and Labor Relations. Before moving to Cornell, he directed labor law research at the NAFTA Commission for Labor Cooperation. And I'll just say as an aside, Lance is my go-to for any time I have an international law question or problem. I can ask him and he will know the answer off the top of my head, or off the top of his head. Our final speaker is Desiree Leclerc. She is a new faculty member at Cornell's ILR School. Before that, she served as Director for Labor Affairs at the Office of the United States Trade Representative, and for nearly 10 years as a legal officer for the ILO. Desiree, I didn't give you a chance to say hello. Would you say hello real quick?
Hi, everyone.
Great, thanks. And Janice, I don't think I gave you a chance to say hello, but you now have the floor. Give me just a second and I will share your PowerPoint and you can go ahead and get started.
Great, thank you, Rick. To everyone, my job today is in a sense to give you the 30,000-foot overview in 7 minutes or less of our topic and really lead in also to the other three. One thing about our title about moving to, and I'm going to stress this throughout my presentation, is that labor rights in free trade agreements is really a journey, and it's we'll see this journey going back and continuing into the future, I'm sure. Next slide, please. Next slide.
Yep.
This just says, and it's in my mind, NAFTA was the first.
Janet, you should speak a little bit louder. I'm getting on the chat that people are having a hard time hearing you.
Okay. In my mind, NAFTA was the first time in the United States that general public consciousness was aware that maybe the US could lose out from trade agreements, and this fear over loss of jobs particularly, that is still obviously a big theme today, one of the responses was, well, not just free trade, we should have fair trade, and that leads to this idea that there should be labor clauses in free trade agreements, and that the parties would agree to abide by certain standards. Well, that leads you into the next issue. Next slide. What standards? And I think over time we see this not changing, but being clarified. I mean, we're just saying some general principles. Are we pointing to an ILO convention? Are we looking at something defined in national law? I mean, and if so, which countries, when you have more than one country? Next slide. The timeline, real fast. Well, 1993 was when the NALC, the side agreement to NAFTA, was negotiated. Took effect the next year, the agreement. And then globalization, which was present, of course, but it really burst out in a big way when the WTO opened its doors on the beginning of 1995. For those of you who don't recognize it, that's the WTO headquarters in Geneva on the right. Within 1 year, this idea that somehow trading preferences or should be linked to labor rights observance was pushed at the first ministerial meeting of the WTO. And I should tell you, immediately that idea was rejected by the WTO, who took the position that the ILO is the appropriate UN body that takes care of it. So yes, it went to the ILO that was already working on something. In 1998, the International Labor Conference adopted a Declaration of Fundamental Principles and Rights at Work. Back to that in a couple of slides, but I just say, if anything, that declaration has become more important in many ways than people even realized in 1998. Next slide. Next slide, please. Moving.
Sir, it's slow.
Moving to the United States, then, of course, we've been negotiating trade agreements, and of course, we had trade promotion acts, but in 2002, there was many important updates there, but especially the changing of a certain phrase there where it says that the parties, the signatory parties to an agreement, would commit to strive to ensure that their laws and regulations and practices met the commitments or these labor rights listed in the agreement. I only mentioned fast track for those that are not familiar with this. It is the fact that for some time, what happens is that Congress gives the executive branch the authority to negotiate a free trade agreement without intervening along the way. But then at a certain point, the negotiated agreement comes to Congress for approval. There can be no amendments. It's either approval or rejection. And as a result of that, what's happened is Congress, as you will see, has turned around to the executive branch through these statutes, and you'll see it on the slide there, and has said to the executive branch, okay, you have that authority, but by the way, when you're negotiating, you have to make sure that the agreement meets what we're telling you it should do. So 2007 is the May 10th agreement, and there the phrase changes, maybe because there was some dismay that parties weren't striving enough or fast enough. And now it says the parties commit to adopt and maintain certain laws, regulations, etc. Also, in specifying the fundamental rights from that 1998 declaration, this is the first time that all 4 fundamental rights are listed, and it might be curious to you, but the one that had been not listed per se before was about discrimination in employment. And in 2015, I just want to say that's the most recent, the Trade Priorities and Accountability Act. It's the most comprehensive and specific statement of rights, and it shows this journey as Congress or the parties in Congress have looked at experience and said, wait, we better be more specific about what we'd like to see in an agreement. Next slide, please. Here's the declaration. You will know that's the exact wording of it. And I'd only say that the declaration itself is like headlines. Who could be against child labor? Everybody, but then you say, what is child labor? But that's the declaration. Those are the 4 fundamental principles. And at the bottom, I mentioned that all US FTAs also include this phrase, acceptable conditions of work with respect to minimum wages, working hours, and safety and health. Next slide, please. The 1998 declaration linked to 8 ILO conventions. They're called core conventions, and I list what they are. They become quite important, but it's, as I said, it's like if you read the newspaper and you see a headline, you get a general idea of what it's about, but you have to read the story to get more detail. And in some ways, that's what the core conventions do with regard to the 4 fundamental principles. Next slide, please. I go back to this. Once you see some of the complexities, and I'll only use child labor, we're all against child labor, but if I say, can a 15-year-old work 40 hours a week in a factory in sort of a regular job, not anything dangerous? Well, just being against child labor doesn't give you the answer. So you can see, does the standard in the FTA just a principle? Does it relate to a specific convention? Are we pointing to some law or practice? And also, what form of dispute resolution or enforcement are we looking at? Next slide. I thought about changing this to strengthening, but it's really the same thing. We learn from experience, and that's what you see as you look at U.S. free trade agreements, that you look back to the last few and you say, what do we think didn't work out exactly what we expected? The Trans-Pacific Partnership was negotiated. It was signed by 12 countries in February of 2016. When President Trump was elected in November, the United States declined to ratify, but the other 11 countries did ratify, and that includes Mexico and Canada, and that is in effect. In listing the 4 fundamental principles, it's listed a bit strangely, one of them. And also there's a footnote that makes you think, are the conventions linked in any way, or is it a reference? You're not sure, out of uncertainty. The other thing about past experience is, well, we've only had one arbitration case arising out of a U.S. free trade agreement so far. It's quite surprising. And it took 9 years to reach a decision, which is hardly prompt. And so many people were disappointed by that. And also something that was surprising, in that case, severe violations of basic labor rights, that was proven, but the complaint, the panel said the complaint failed because the complainant had not proven that the violations were done in a manner that affecting trade. That's a phrase that's been in all FTAs, not surprising because they're trade agreements, but the way the panel looked at it, it's almost an insurmountable hurdle. Next slide, please. So when we go now to the current USMCA, which all of you know was being negotiated. President Trump said he didn't like the original one, wanted to renegotiate it. But then in November 2018, the Democrats got a majority in the House of Representatives, and suddenly that perhaps made it possible to be a little stronger on certain points in the chapters relating to labor. So I'll only mention 3. There are many things to be mentioned, but it expressly states the 4 ILO fundamental principles, what exactly. And there are references or links to the 8 core conventions. So the parties agree to adopt and maintain laws and regulations that are consistent with these fundamental rights. In the discussion, I hope we can look at this a bit more. It says, the next one, incredibly important, if there is, if we go to dispute resolution, if a failure, if a violation is proven, it is presumed that it was in a manner affecting trade. So it's a rebuttable presumption, but it certainly is very important from the complainant's point of view about what has to be proven. And finally, besides having arbitration and other forms of dispute resolution, there is an additional one for complaints regarding freedom of association, and that is called a facility-specific rapid response mechanism. This is completely innovative, and we will wait to see what that means. So I will conclude here by only saying that this has been, I consider it a journey, and a journey we are still on, and I will look to the others to fill out some of the details. Thank you.
Thank you, Janice. I forgot to mention up at the top, everyone, please, if you have questions, type them into the chat function of your Zoom, and I will be monitoring those and following up. At the end, we'll have plenty of time for some Q&A. Our next speaker is Jim Brudney. Jim, the floor is yours.
Thank you, Rick. And thanks so much to LERA and ISLSSL for co-hosting this webinar. At the start, I just want to say I'm appearing, notwithstanding Rick's introduction of me, as a member of the Fordham Law faculty, not a member, what I say is not as a member of the ILO Committee of Experts. I will talk mainly about provisions addressing the international labor norms and also several new forms of commitment related to specific workplace conditions or protections. And as time allows, I will briefly describe one additional change, which is a new labor value component for automobiles and trucks. So on international labor norms, Congress's, as Janice was referring to, Congress's labor-related trade negotiating objectives prominently include promoting respect for worker rights and the rights of children consistent with core labor standards of the ILO. Article 23 of this new agreement, which I will occasionally refer to as USMCA, it doesn't have a very good abbreviation, includes a statement by all three countries affirming their obligations as ILO members and a commitment to adopt and maintain in its laws and practices the fundamental rights as set forth in the 1998 ILO Declaration on Rights at Work. And these again are freedom of association and collective bargaining, the elimination of forced labor, the abolition of child labor, and non-discrimination. This adopt and maintain language has been in U.S. trade agreement labor provisions since 2007. Certain intriguing aspects of Article 23 appear as footnotes. And one footnote that I want to spend a minute on is relates to the right to strike as part of freedom of association. There has been a heated disagreement within the ILO since about 2011 involving this. The International Employers Group has contended that there is not an international right to strike as part of Convention 87 on freedom of association, and that ILO supervisory committees explaining the contours of such a right have exceeded their authority. The International Workers Group and the great majority of governments have disagreed, including the United States, when the Obama administration made clear during key discussions in 2015 in Geneva its support for the existence of an international right to strike. Still, it is notable that the Trump administration, in what is footnote 6 to the labor provisions, drives home this position with emphasis as part of the trade agreement. The footnote says, for greater certainty, the right to strike is linked to freedom of association, which cannot be realized without protecting the right to strike. It should be noted, too, that the international right to strike is more protective than the U.S. right in certain respects. For instance, international law provides that public employees have the right to strike with rather limited exceptions, and that the hiring of permanent replacements for lawful strikers is prohibited. But notwithstanding the sort of elevation of ILO norms, including the right to strike in Article 23, the impact on U.S. domestic law may well be limited. Commitment to the Declaration on the Rights at Work is not the equivalent to commitment to abide by the conventions themselves, which are treaties to be ratified by national governments. And while Mexico and Canada have in fact ratified all 8 fundamental conventions on which the Declaration is based, the United States has ratified only 2, the abolition of forced labor and the elimination of the worst forms of child labor. There are unresolved questions as to the force of being obligated under the Declaration for non-ratifying governments like the United States. Relatedly, the ILO supervisory bodies, the Committee of Experts and the Committee on Freedom of Association, do monitor convention compliance issues, but they do not have a role in reviewing declaration compliance. All of this is to say that the scope and meaning of adopt and maintain in law and practice the fundamental rights under the ILO Declaration remains to be more fully developed in this trade provision context. In addition to the embrace of ILO norms, Article 23 includes 4 notable commitments to specific worker protections. One, in Article 23.6, requires the parties to prohibit the importation of goods produced by forced labor and to establish cooperative efforts toward that end. The TPP, which, as Janice said, the US did not ratify, but Mexico and Canada did, had actually required parties only to discourage such importation produced by forced labor. So this is a strengthening. A second provision, worded a little less robustly, commits the parties, quote, not to fail to address violence or threats of violence against workers for exercising their labor rights. And violence against workers seeking to pursue labor rights has been a particular issue in Mexico in prior years. A third provision commits each party to ensure that migrant workers are protected under its labor laws. Such protection has arguably been less than complete under at least one Supreme Court decision involving the National Labor Relations Act, which we can discuss during the questions if people are interested. And finally, each party commits to implement policies that it considers appropriate to protect workers against employment discrimination based on sex, sexual orientation, and gender identity, and also to provide job-protected family leave and protect against wage discrimination. The provision on sexual orientation and gender identity has a special twist that I'm going to leave to Desiree to explain. So both the commitment to ILO norms and the new forms of specific labor protections are important signs of progress. The question will be how they are monitored and enforced by US governments and by other governments against the US as applicable, and whether the sort of familiar refrain that has accompanied prior FTA labor provisions from worker groups, which is that the commitments end up as broken promises, whether that refrain will repeat itself several years down the road. So finally, just a word about the labor value component. Prior FTAs and indeed USMCA have included requirements mandating that a set percentage of the value, of the product's content be created within a designated geographic area. This is the first FTA with a labor value content requirement. It's directed specifically at the auto industry, and up to eventually 40 to 45% of auto or truck content will have to be made by workers earning at least the equivalent of $16 an hour. This is the US response to the reality that average manufacturing labor costs in Mexico are much lower than that, estimated at about $4.80 an hour according to one recent study. So the goal here is to create movement along the supply chain by having more high-value auto components built in the United States and Canada rather than in Mexico. That said, there are still a number of details to be worked out as this becomes implemented. One may involve whether labor value content is calculated for individual factories or for an entire corporation. Assuming that the answer is for an entire corporation, as at least some language in the agreement suggests, then a VW factory in Puebla, Mexico, for instance, might be added to the VW factory in Chattanooga, Tennessee, and the combined wage levels would be considered in order to assess labor value content. In short, it's not yet clear how companies will respond to new rules and the extent to which these labor value content requirements will result in more jobs in the United States. Thank you.
Thank you, Jim. Our next speaker is Lance Compa. Lance, the floor is yours.
Thanks, Rick, and thanks to the Society and the Association for putting this program together. One of the most important results of the USMCA is a far-reaching labor law reform that Mexico enacted in May 2019 pursuant to the trade agreement. This really shows the potential for linking trade negotiations to labor law reform in individual countries. As part of this agreement, Mexico agreed to break up the corrupt, what's called protection union system that has prevailed in Mexico for decades. This is a system in which employers choose a union that will protect them, that's why it's a protection union, protect them from having a real union chosen by workers. In many cases, these sweetheart deals are arranged even before a worksite opens and before any workers are hired. Often, workers don't even know that they have a union or a contract until they try to form a real union of their own choosing, and the incumbent protection union stops them. Until now, a tripartite labor board system of government, employer, and protection union representatives served to maintain this arrangement. The fix was in because all three benefited from the system. The government attracted investment, employers got compliant unions, and unions got dues, usually 2% of payroll, that employers paid directly to the union. Nothing was deducted from workers' wages. The employer just sends a big check to the union every month. The reform law enacted by Mexico last year replaces these tripartite boards with new labor courts in the judicial branch to handle labor disputes, both individual and collective. The law also creates a new super agency that combines the functions we know as those carried out by the National Labor Relations Board, the Federal Mediation and Conciliation Service, and the Office of Labor Management Standards. But this changeover is not instantaneous. The reform provides for a 4-year transition period to the new system, and that transition has really just begun. The labor law reform also introduces new levels of transparency. All collective bargaining agreements in Mexico will be put online at this new agency, available for the world to see. The law also requires gender parity in union leadership in the same proportion as the gender balance in the workplace. The reform law requires secret ballot votes on ratification of all CBAs and election of union leadership, and when two unions are competing for bargaining rights, typically the incumbent protection union against an independent union seeking to replace it. The employer cannot, as it has in the past, recognize a protection union in advance or collude with its protection union to block independent union organizing. These reforms in the Mexican labor law system serve as the basis for complaints under another innovative feature of the USMCA, which Janice mentioned, called the Facility Specific Rapid Response System. This allows for complaints by the US government against an employer in Mexico, a company in Mexico, for violations of the new labor reform law. Not just against the Mexican government for failure to effectively enforce domestic law, which is, has always been the basis of complaints under free trade agreements. And it also remains available in the USMCA. The rapid response system is a separate facility-specific one. It's limited, this rapid response mechanism is limited to freedom of association issues only, organizing and collective bargaining, not other subjects like child labor and discrimination. It involves alleged violations at a specific covered facility in several trade-related manufacturing and service sectors. A government filing a complaint needs only a good faith belief that workers at a particular workplace were denied freedom of association rights. And there's no requirement for exhaustion of domestic legal procedures. The mechanism also creates a rapid sanction tool. It allows for a 45-day period to resolve a dispute amicably, but if it is not resolved, the complaining government can trigger formation of a 3-member rapid response panel to determine if workers' rights were violated. At this point, the complaining government can provisionally apply trade sanctions, putting the company on notice that its exports of goods or services are subject to retroactive tariffs if the rapid response panel finds there was a denial of freedom of association rights that was not remedied. The panel would normally make its determination within a 60-day time frame, very rapid compared with all the other procedural mechanisms. These sanctions can even be ramped up to hot goods type seizure of goods if the company is a serial offender. Now, this 3-person panel, they are not government officials. They are private sector individuals drawn from a roster of 6 US nationals named by the United States, 6 Mexican nationals appointed by Mexico, and 6 non-US or Mexican nationals jointly chosen by the 2 governments. We might soon learn how this facility-specific rapid response mechanism works in practice. The AFL-CIO announced on September 3rd that later this month, it will ask the USTR to file the first complaint against a company in Mexico. So let's all stay tuned to see what happens. And let's pay attention to the overall course of labor law reform in Mexico in the coming months and years. That's it.
Thank you, Lance. Next up is Desiree Leclerc. Desiree?
Thank you, and thanks to the association, the society, and my fellow panelists for having me here. Like Professor Bredney, I also have worked with the ILO, and I have also worked with USTR, as Rick had mentioned, and I just want to say at the outset that my comments are not attributable to either of those institutions. They are my personal observations alone. Nevertheless, having worked for the ILO and for USTR, I'm in a unique position to see the manner in which the international labor standards of the ILO are interpreted and applied in that organization and how they're applied in the United States. And it's through those observations that I'd like to provide a different perspective in the question of USMCA and labor provisions and trade agreements. At the outset, I'd just like to state, as Lance has implied, the labor provisions and trade agreements have tremendous potential to drive really important, critical, and positive legislative change. In fact, I think USTR and DOL could do a better job of highlighting some of the benefits of labor provisions and trade agreements, although I recognize the political fallback of doing so. Nevertheless, I'd like to manage our expectations just a little bit when it comes to what kind of reforms or drives of change we might be able to see. And in particular, I look at the United States. As Janice had mentioned, I like her metaphor of the newspaper. So we have the headlines and then we have the details or the meats of the standards. And as Jim had mentioned, our trade agreements address the broad strokes. They're the headlines, they are not the details. Nevertheless, those of us who are participating in this webinar are coming broadly from a labor rights perspective. Therefore, we're all aware that the devil's in the details. In other words, which individuals are covered and given protections? What is the extent of the coverage of protections? Who can engage in protected and concerted activities and be protected? And what kinds of remedial measures are available? In the United States, for instance, we have the National Labor Relations Act. It provides the right to form unions. They have the right to strike. Employees have, the right to bargain, and employers have a duty to bargain. Nevertheless, labor rights advocates in the United States are incredibly frustrated at the inability to gain legislative change. They feel as though not enough employees are covered, remedial measures are inadequate, and that our protections are being eroded for corporate interests. In other words, broad strokes don't always cut it. Many times, labor advocates look to trade agreements as a viable alternative to their frustrations with the courts or legislative processes. They hope that by incorporating the international labor standards of the ILO, they might somehow drive change to United States national legislation. Alternatively, those even outside of the United States look to labor provisions and trade agreements and hope that somehow the United States is exporting the ILO's labor standards, and in so doing, providing the ILO's toothless mechanisms with some form of dentures, providing teeth to the ILO standards. Jim had mentioned briefly that there are gaps, though, in US legislation and with the rights that are incorporated in our trade agreements. As he mentioned, a lot of these issues take place with freedom of association and collective bargaining. Now, while the ILO does not have the mandate to supervise conventions that have not been ratified, a special body, the Committee on Freedom of Association, can supervise complaints on freedom of association and collective bargaining. And it is through those comments that we can understand better the gaps between the ILO standards and the laws and practices in the United States as they currently stand. And in that respect, I'd just like to draw attention to a few broad categories of gaps that have continued, notwithstanding the existence of labor provisions in United States trade agreements. The first is the scope of coverage. Again, Jim had mentioned that our scope of coverage might be more narrow than the ILO, and the ILO has certainly confirmed that. The first subcategory is graduate students. Now, those familiar with the National Labor Relations Board, which is our federal agency mandated to interpret the National Labor Relations Act, has flip-flopped over the years with respect to the status of graduate students. Are those graduate students considered employees such that they can benefit from the protections of the Act, or are they excluded? Initially, in Columbia University, the board found that they were excluded, and then that's gone back and forth until Brown University in 2004, where the NLRB held that graduate students were not employees under the Act. As such, their petitions by unions to represent those workers for the purposes of collective bargaining were dismissed. The ILO took up this case in case 2547. They recalled that all workers, without distinction whatsoever, including without discrimination in regard to occupation, should have the right to establish and join organizations of their own choosing. The ILO committee went on to say that it has always conferred a very broad meaning to the sense of the term worker, and has found on various occasions that this principle applies to teachers, instructors, and so on. Now, some might want to correct me at this point and say, no, but Desiree, in 2017 at the new Columbia University, the NLRB reversed itself again, finding that graduate students are indeed employees. The ILO, in fact, noted its satisfaction with this decision. Nevertheless, those of us who follow NLRB drama have noted that Chairman Ring has expressed his intention in rulemaking to codify the exception of graduate students as employees under the NLRA. And in fact, even though it was open for public comment and got vociferous opposition of this, the chairman and the board have expressed their intention of codifying and passing this rule imminently. Now, in an ideal world, if we felt that the labor provisions and commitments in trade agreements might drive legislative action, one would imagine that the NLRB would have done the following. First, it would have been aware of case 2547 and the ILO's comments. It then would have realized that its rulemaking might potentially violate the ILO's norms, which would have arguably been incorporated in the US FTAs. The NLRB would have then either rolled back its rule or at least would have consulted USTR and DOL about the possible implications of this disconnect. Now, I have no inside knowledge or am not privy to any of these conversations, and I found nothing in the public. I would invite any type of information to this respect, but something tells me that those conversations have not taken place and that the NLRB does not find itself so bound. Moving from graduate students to supervisors, those who are familiar with NLRB case law are aware of the Oakwood Trilogy in 2006, which broadened the definition of supervisors, and notably, supervisors are excluded from the protections of the National Labor Relations Act. In case number 2524, the ILO addressed the Oakwood Trilogy and stated that it expressed its serious concerns that the new definition of supervisor, quote, might lead to the exclusion of wide categories of workers from protection of their freedom of association rights and to a clogging of the representation and collective bargaining process through an increase in appeals filed by employers with a view to challenging the status of employees in bargaining units. Oakwood Trilogy remains good law. Turning to protection against anti-union discrimination, this is another one of the details in the right to freedom of association, not spelled out in trade agreement, but spelled out under the ILO's norms. the ILO examined the famous Hoffman Plastics case, a 2002 Supreme Court decision which held that an undocumented worker, owing to his immigration status, was not entitled to back pay for lost wages after being illegally fired for union organizing. In case number 2227, the ILO found that by limiting those protections, the remaining remedial measures under national law were, quote, inadequate to ensure effective protection against acts of anti-union discrimination. The ILO most recently repeated this observation in 2011. So what does that mean for freedom of association in the details? One can see clearly that while it is easy for FTAs to mention principles and rights such as freedom of association and collective bargaining, the headlines do not necessarily match the story underneath. Jim had mentioned a new and enticing footnote, and this is really a great story unraveling before us. And under Article 23.9, the United States, Mexico, and Canada agreed to a groundbreaking provision under anti-discrimination where they basically prohibited discrimination in the workplace on the basis of gender identity. Now, when these conversations first came about, gender advocates were incredibly excited, particularly in the United States, because Title VII in the United States, which prohibits discrimination, arguably did not apply to gender identity, and the courts were split on this. So gender advocates hoped that by incorporating this protection, that would trigger, flag some kind of acceptance in the United States. To dispel any hope of that, the United States included footnote 15, which Jim alluded to, basically stating the United States' existing federal agency policies regarding the hiring of federal workers are sufficient to fill the obligations set forth in this article. The article thus requires no additional action on the part of the United States, including any amendments to Title VII. So the timing of this is very curious. After drafting that footnote, a case arose in the Supreme Court in April 2019, Bostock v. Clayton County. It's a consolidation of 3 cases that ask whether Title VII's ban on sex discrimination extends to discrimination on the basis of gender identity. Shortly thereafter, in August, the administration issued an amicus to Bostock, emphatically urging the court to rule against the plaintiffs and arguing that Title VII did not extend to gender identity. So that was the basis in the thinking of the administration at the time of the drafting of the USMCA footnote. In December thereafter, the United States finalized the text of USMCA, including its footnote, and submitted the implementing legislation to Congress. By the way, there's American jurisprudence addressing this and finding that the final act of an agency is when the implementing legislation is submitted to Congress. So according to our jurisprudence, this is when the administration carried out its final act of the trade agreement. Afterwards, about a month after, Congress enacted the implementing legislation, expressly endorsing the labor rights commitments contained in the labor chapter. In June after that, the Supreme Court issued its Bostock ruling in which it held that, in fact, Title VII protections do extend to discrimination on the basis of gender identity. 2 weeks after the Supreme Court's holding, USMCA entered into force without any amendments. I think a legal question exists as to whether or not the intention of the footnote will rule, or whether moving forward, potential claims could be brought on the basis of discrimination for gender identity. And your guess will be as good as mine. You know, it's funny, in the United States, we often squibble over the balance of powers between Congress and the executive with respect to trade agreements, but I think we're about to see a new contender with our judiciary. Bostock aside, when it comes to looking at gaps in legislation and whether or not trade agreements might drive national legislation, the USMCA implementing legislation, which we haven't yet discussed, addresses that on all fours. Under Section 102, it states expressly that no provision of USMCA, nor the application of any such provision, which is inconsistent with any law in the United States, shall have effect. It also states that no state law may be declared invalid on the ground that the provision or application is inconsistent with the USMCA. So this all takes us to the question of, all right, if our labor provisions do not contain the details, what is it that they're exporting, and is this a good thing? Some might argue, in fact, that even if it's considered an ILO light, even if it's just the headlines, being able to take the ILO light and attach it to sanctions is better than not having any labor provisions at all. I would agree with that. And in fact, I don't have the time to get into it, but I would argue that it is better to have just the headlines than to incorporate all of the minute details in a trade agreement, such as the EU model. Thank you very much.
Thank you, Desiree. I'll remind all of our participants, or all of our listeners and viewers, that we have a chat function set up. Please feel free to add your questions. I'm going to get us started. We have looks like we've got about 13 minutes left for Q&A. I'm going to get us started by sharing my screen, which has a couple of questions up. And I'll start by asking I'll just throw it out to all the panelists, and whoever wants to can get us started. Jim mentioned special wage laws for the auto industry. And my question is, does the USMCA have different rules for different industries? And what does that say about about the future of US trade negotiations? Not just with CAFTA, but with other trade negotiations. Is it going to be industry specific? Or are we going to have a set of rules for the auto industry and the garment industry and the furniture industry and whatnot else? Anyone?
I'll take that, Rick. It's okay. In any trade agreement, there are different, say, rules for different industries, different products. Rules of origin relate to specific products, but on the labor value issue that Jim commented on, it is an innovation, but it was directed mainly at the auto industry. One might think that you could take the upside that at least, get your foot in the door if you're on the labor side, that this is something that is looking at trying to have high value jobs stay in the United States, or at least look at how value is distributed across the supply chain. On the negative side, you might think that attention is being focused only on an industry that has significant, or workers that have significant political influence in certain states. Can I add something to that regard? And it's something that Desiree just said. In that Article 23 about that Title VII satisfies the US requirements on discrimination in employment, that we have laws and practices. I'd like to highlight something else. Gender identity, of course, is very important, but let's get back to something that's very old. How about equal pay? It's 1951, the ILO Convention number 100 says equal pay for work of equal value. American law does not say that. Ours is very, very substantially narrower, only equal pay for this if you are doing the same or substantially similar work as a man. We specifically have said at the ILO, the United States, that we refuse to, sign up for Convention number 100 because we don't have that and we don't want it, if I want to put it so bluntly. So if you read that footnote, you think, oh, this is wonderful. We're agreeing about non-discrimination in employment, and here we have Title VII. But it's only people who understand very well what Title VII says, and the Bennett Amendment to Title VII basically says you have to be able to make a claim under the Equal Pay Act of 1963 to succeed on equal pay. So that's another area we are very narrow, and it seems like we're maybe imposing a higher standard on other countries than we ourselves are willing to impose on ourselves.
Rick, if I can step in on not only that first question, but really the way in which the second question comes up, which is whether we are hypocritical about our compliance with ILO standards. I mean, I think one of the things politically that has been true in the United States is that, you need a 2/3 majority in Congress, in the Senate, in order to get ratification of a convention, which is a treaty. And the general view that we have taken, almost philosophically, is that we can't ratify a treaty, a convention that is inconsistent with state law, with national law. And in the case of the right to strike for public employees, we defer to state law. And I think That's not the way that every country in the world approaches figuring out whether to ratify an ILO convention. Ratifying an ILO convention is often regarded as an impetus to change national law, to commit yourself to what is a transnational norm of enduring, I mean, that was, after all, created through an international parliament that had to go through 2 rounds of promulgating this convention, and in which every country, every member state, 187 of them, was involved. And so a different way to look at this would be to say, now that we have participated in this, and particularly now that we are expecting our trading partners to comply with the norms that emanate from these conventions, we ought to take legislative steps to walk the walk and not just talk the talk.
I do want to speak up though about question 2. I don't know where the wording of this came from, but I just want to make it perfectly clear. It says, as all the speakers mentioned, the US is a world laggard. I don't think a single person has suggested that the US is a world laggard. What we've done is noted inconsistencies between the US laws and the international labor standards, but we have not made any comparison between US laws and the national laws in other countries. Having worked for the ILO, I can tell you that there is no correlation that I saw between the ratification of a convention and the perfect compliance with the convention. It is a legal step, but it does not necessarily mean compliance. The United States, if you look across the board and do a comparison of our laws and practices, even with all of our weaknesses mentioned, the United States is certainly a driver of good international labor standards. We just have a lot of room for growth. So I just want to make that clarification.
Good point. Do you all see, I guess I'm going to question 3 here. Do you all see a chance that US labor law could change in response to complaints that are brought as a result of USMCA? And obviously that's going to change. A lot of that will depend on what happens in November. Perhaps I should rephrase the question. Where do you see as being the most potential for change, or the best potential for change in US law?
Lance, I thought you were going to say something.
Yeah. Well, I think the short answer is, I mean, I'm reading the question. Do you see potential for complaints against the U.S. on freedom of association? I think the answer to that far is yes. Lots of potential for complaints against the U.S. on freedom of association issues. That could lead to changes in U.S. law. I think the short answer is no. Because our labor law is really hardwired in the history of labor industrial relations and labor struggles and class conflict in the United States, and it's not going to be changed by the intervention or application or invocation of international labor standards. It's a struggle that will have to be carried out by working people, inside the United States to win the legislative reforms that are needed. Now, if Joe Biden wins the election, then the question of labor law reform will once again be front and center on the legislative agenda, just as it was when Obama got elected, and just as it was when Clinton got elected, and nothing happened because there are enough conservative Democrats, even when the Democrats are in a majority status, there are enough conservative Democrats who don't go along with the labor law reform. So that challenge is still going to be in front of us.
Let me just build on that a little bit, because although I totally agree with Lance that this will be a domestic political battle and not a battle that is shaped by international norms, there is something a little bit different about the current situation, which is that the House has passed a significant labor law reform package in February of this year, which would address, I mean, it wasn't meant to address international objections or international labor law objections, but it does address a number of issues that Lance, Desiree, Janice, and I have both referred to and written about. And so part of the question is, what will happen if the Senate becomes Democratic? and what will happen if the filibuster is abolished, as a number of Senate Democrats have said they will move to do. So, I mean, I think the sort of forecast is a little bit different. It's not just whether Joe Biden is elected, it's whether the makeup of Congress and the rules that govern legislative change. I mean, when you have a filibuster, as has been true in the Senate for well over a century, it's a Senate rule, it's nothing constitutional about it. You need 60 votes, and you're not going to get 60 votes for labor law reform. That's pretty clear. But whether you might get 50 votes is a different question.
So we only have a couple of minutes left. Perhaps a good place to leave would be with question number 4, which is, does USMCA create room for labor solidarity across the 3 countries?
I'll say quickly, I think the answer is yes. And actually the experience under the NALC, the NAFTA labor agreement, for all of its weaknesses, one of the important spillover effects of that agreement was that it drove a new, really unprecedented level of collaboration and cooperation and solidarity among trade unions and trade union lawyers and labor rights advocates in Canada and the United States and Mexico. And in fact, the work of that coalition was part of what drove the impetus for labor law reform in Mexico that came out of the USMCA. So I think the answer to that is a resounding yes.
Anyone else like to comment?
Yeah, I would agree with Lance on that. I mean, I feel like one of the things, I mean, NAFTA is justifiably criticized in a number of respects, but the sort of cross-border worker strategizing and collaboration aspects have not always been fully valued in the context of, as well as the reality that this was the very first set of labor provisions in any trade agreement. And so, people were inventing things for the first time. And the fact that the enforcement aspects and the dispute resolution aspects didn't work out nearly as well as maybe people had hoped. The public education and the cross-border collaboration aspects were important sort of in the bone structure, and I think that they have continued in the new agreement, and one hopes that with more potential for enforcement, the rapid response mechanisms and other forms of enforcement, that cross-border collaboration will continue to deepen.
Can I add one thing, and it's not sort of related to this, and we've been talking about, we're near the end. When I mentioned Trans-Pacific Partnership for a reason. If Joe Biden should be elected, I think the United States may ratify the Trans-Pacific Partnership. As I said, Canada and Mexico already have. And we do have free trade agreements with other signatories. It would be the largest trading bloc. And of course, Obama, and when Vice President Biden was there, really pushed the negotiations for TPP. They were very much behind it. So I think what we are now doing under USMCA will be very important if Biden should be elected, because I see us signing another trade agreement. There might be some minor negotiation then, and it might bring in some of the things that have been inserted in the USMCA.
Thank you. Well, that brings us to the end of our webinar. I want to thank all of you for joining us. I want to give a special thanks to our speakers, Janice Balache, Jim Brudney, Lance Compa, and Desiree Leclerc. And a special thanks also to our co-sponsors, the International Interest Section of LERA and the US branch of the ISLSSL. Thank you all very much and have a wonderful day.